I have 14 motions that I think I can go quickly through if the court would allow me, because I have them numbered a certain way. The first one is motion to declare sections 921.141 and or 921.1 subsection subsection 6, subsection H, Florida statutes. It's basically the hack motion.
Okay.
We're declaring that be declared unconstitutional facially and as applied, and I would rely on my memorandum of law.
Okay, that's fine. And just so, Mr. Hernandez, it will make my life simpler. When I was given a list of the pending motions by the state, and they were broken down as far as numbers and when we were going to hear them. So I have them broken down by the dates that we originally scheduled to hear the motion. So for example, it would be helpful to me, I'm looking at the motions that were initially scheduled to be heard February 26th. And as to Rashad Murphy, the motion to preclude the imposition of the death penalty.
I have them numbered my way. I didn't have them, but I can get to whichever one you want to get to.
Okay.
Which one is it?
It's the motion to preclude the imposition of the death penalty, and specifically that the retroactive application of a death penalty statute enacted in 2016 or 2017 violates Article 10, Section 9 of the Florida Constitution.
Judge, I guess I am having difficulty finding it.
Okay. All right. Okay. So hold on. Let's do this. Murphy. I'm going to pull out all of Mr. Rashad Murphy's motions that I have, and we'll go through those.
I apologize.
All right.
I did not have your numbering, and I just numbered them separately myself. The first one was the heinous, atrocious, or cruel aggravator motion that I just referred to.
All right. Give me just a moment.
And Your Honor, before I forget, I would request to move orally to adopt any death penalty motions that were filed by co-defendants.
Okay, granted. We have about 60 motions, so just give me a moment. Okay, I think I have pulled out all of the penalty phase motions that were filed on behalf of Mr. Rashad Murphy. So tell me, Mr. Hernandez, which one you want to start off with again?
The first one that I mentioned, Your Honor, was a motion to declare. It's the heinous, atrocious, or cruel aggravator motion, asking that section, those sections of the Florida statute be declared unconstitutional.
What's the
facially
actual? Oh,
and
here it is.
applied.
Okay, just making sure. So you're arguing motion to declare sections 921.141 and or 921.1416H Florida statutes heinous, atrocious, or cruel aggravator and or the current 6H interim instruction unconstitutional facially and as applied. Correct?
Your Honor, and I'm relying on my memorandum of law that I've attached, so I don't have any further argument.
Okay, and state, you filed a response to that as well?
We did, Your Honor.
You're relying upon that?
Yes, Your Honor.
Okay, I will deny the motion. Okay, what's
Your Honor,
next?
the next one on my list is titled Motion in Limine Precluding Improper Penalty Phase Argument. And Mr. Harmon has indicated that he does not object to it.
Okay,
We have no objection, Your Honor. We won't want to get any of the arguments in that.
okay, that motion is granted.
Your Honor, number 3, I have motion in limine regarding reference to non-enumerated mitigating circumstances, and I believe the state does not object.
We do not object.
Okay, that one is granted.
Your Honor, my next one is number 4 is motion to allow testimony of the impact of defendant's execution on family members. The state, I believe, objects to this one. I think they object to the rest of mine. My argument, Your Honor, to this is the fact that mitigation can be anything. And the fact that he's greatly loved by family members should be something that I should be able to present to the jury. And I would rely on the Lugo case that's in the motion 845 Southern 2nd 74. It's a Florida Supreme Court case, 2003.
Okay, Mr. Hartman.
We filed a written response objecting to this. I can make additional argument for which is the.
What is it specifically, Mr. Harmon, are you concerned? I mean, you would concede that obviously the defendant can call witnesses to testify as to the why it is that Rashad Murphy should not be executed, and that, you know, if he's a good brother or son or provider or whatever it may be, right? And so, but I guess where we're having an issue is whether or not those same family members would be able to testify as to their feelings should Mr. Rashad Murphy be executed, correct?
The impact of the defendant's execution of this is a future event that has not occurred. We don't know when it will occur. We don't know if the defendant will even ever be executed or if he would die naturally in the Florida State Prison. We don't know if the family members would still be alive when he was executed. It is such an unknowable fact for them to testify about. We believe that's improper. I have no objection to family members taking the stand to express to the jury why they believe his life should be spared.
Okay. Let me look at Lugo, and I'm going to take that one under advisement. So,
Yes, Your Honor.
okay, let you know.
Your Honor, the next one is titled Motion to Declare Florida's Death Penalty Unconstitutional. And in parentheses, it states unreliability. We believe that the argument, Your Honor, is that the fact-finding process cannot be deemed sufficiently reliable to justify imposition of the death penalty. And I would rely on the cases that are cited.
And just to make sure I'm on the same page, motion to declare Florida's death penalty unconstitutional as to unreliability. That's the motion
Yes,
we're
ma'am.
discussing. Okay, and state, you filed a reply, which I have reviewed. Anything further?
No, Your Honor.
Okay, I will deny that motion. Okay,
Your Honor, the next one is it reads motion to declare sections 921, 141, 6I of Florida statute. It's the cold, calculated, and premeditated motion. I'm relying on the memorandum law that I've listed. I'm arguing that the statute is unconstitutionally vague, overbroad, and it is applied in an arbitrary and capricious manner in violation of the 5th, 6th, 8th, and 14th Amendment to the U.S. Constitution, as well as Article 1, Sections 2, 9, and 16 of the Florida Constitution. And I would rely on the cases that are included in the motion.
okay, state filed a reply, which I have reviewed. Anything further?
No, Your Honor.
Okay, I will deny the motion.
The next one, Your Honor, is titled Motion to Declare Sections 921, 141, subsection 8 of the Constitution unconstitutional as requested for proffer of impact testimony and pretrial ruling on whether the danger of unfair prejudice of that evidence outweighs its probative value and or otherwise denies a fair sentencing proceeding. I am basically, that's the objecting to the use of victim impact evidence.
All right, and state, you filed a response.
Yes, Your Honor.
Okay.
We rely upon that.
So I will deny the motion as far as it's phrased that the statute is unconstitutional. Obviously, the case law controls how victim impact evidence actually comes in, which we will comply with. But just as to this motion that it's unconstitutional, the provision of victim impact evidence, I will deny that motion.
Thank you, Your Honor. The next one, which is my number 8, motion to declare sections 921.141 and or 921.141.6b of the Florida statutes and to be declared unconstitutional. It basically, the argument in this motion is the prior violent felony aggravating factor of this section should be declared unconstitutional as vague and overbroad and has been applied arbitrarily and in an inconsistent manner, and I would rely on the cases cited.
Okay, anything further from the state?
No, Your Honor.
Okay, I'll deny the motion. All right, next up.
Number 9 is a motion to exclude evidence or argument designed to create sympathy for the deceased. I think I believe Mr. Harmon can correct me if I'm wrong. He agrees to paragraphs 1 through 4. I will not be, or that he would not be arguing the victim impact for the purpose of seeking sympathy for the deceased or in support of any aggravating factor.
Okay, Mr. Harmon, anything further?
Your Honor, we agree to paragraph 1 through 4 of the defendant's motion. The evidence designed to create sympathy for the deceased is inadmissible in the guilt innocence phase, and we certainly don't intend on getting into any type of sympathy evidence or argument in the guilt phase. Paragraph 5, we disagree with. The admission of evidence concerning the deceased or the circumstances is inadmissible under Florida law in the penalty phase. Well, that's clearly wrong. Circumstances of the case to support multiple aggravators in this case will be argued in the penalty phase. Evidence concerning the deceased would be victim impact. However, Mr. Hernandez did state as to what I told him that we would not argue victim impact is supporting the aggravating factor. So,
That's correct.
Okay. All right. Anything further?
No, Your Honor.
All right. So as to this particular motion, the motion is granted as to items in the motion identified in numbered paragraphs 1, 2, 3, and 4, and it's denied as to paragraph 5. Again, the state is entitled to present victim impact evidence in conformity with the case law.
Your Honor, yes, number 10, there's some repetition here, but it's a motion to limit victim impact evidence. And A through F are the very paragraph or the areas that we're asking for limitations, and we would rely on the case law that's in the motion.
Okay, state what your,
I'm sorry, Your Honor. What is that?
we're on motion to limit victim impact evidence, and specifically, they're requesting only one witness may testify. The witness must be an adult. The state must proffer a proposed victim impact statement in writing.
So guys, this is the defendants are basically so we doing the motions, right? But I do see that we have some questions in regards to the DP. Let me show y'all this document so y'all can kind of see what we're doing here, and so we can all have an understanding on this. Let me show y'all, because we all about trying to figure this out, understand what we're looking at. They do have a DP in Florida, and this is the document. So they do have a notice out here to seek notice of intent to seek the DP. So the state of Florida, by and through, undersigned, assistant, blah, blah, blah. In the event that any of the named defendants are found guilty or plead guilty to a capital felony in this case, in any subsequent penalty proceeding, the state intends to prove and has reason to believe it can prove beyond a reasonable doubt the following aggravating factors. So they list the aggravating factors here. You see in 1 through 4 in regards to the murder of our guy, Foolio Charles Jones. So they are going to seek the DP. Now, I don't know if it has been approved yet. And it does have it on here for the DP. We have Isaiah, Jermaine Chance, Rashad Murphy, Sean Andre Gaffright. Now, I don't think Davion Murphy was in custody at this point in time. He was still on the run. And this was October 7, 2024. Now, this right here, so the defendant's motion to preclude the imposition of the capital punishment. So the defendant, Isaiah Chance, by his counsel, Mr. Chance is charged with to commit free drum. So what they're trying to do is get the DP, I think, off the table for these guys. And I'm just in Isaiah Chance's file, guys. So that's what we're currently arguing now. So I'm gonna take us back into the court just so we can understand what we are doing and why we're here in this current argument in regards to the DP. Because I see that we have different thoughts in the chat. So let me get that back up. I'm gonna get us back in here and we'll finish listening to them argue who shoulda, woulda, coulda, and why
The
not.
court must hold a hearing on the admissibility of the evidence prior to its admission, and the court must consider relevant case law. The testimony must be limited to the prepared statement. No witness may testify if the witness is unable to control his or her emotions.
So Judge, we objected to the remainder of the motion, including that portion. Limits on victim impact of one witness, that's not supported in the case law. There were cases where up to 12 witnesses have been allowed, 12 impact witnesses, even more in some cases. In this case, I'm not sure how many we would call. I know the court is aware we normally try to proffer impact through written statements by the family members. But there have been cases, I have presented impact statements in the past from the community to include friends, family, in-laws, things like that. So I don't believe that these limitations are.
Okay, so you object to only one witness, correct?
I do, and I object to limiting age, that type of thing.
So you object to the witness must be an adult?
I've never called anyone other than an adult in impact. I don't believe in this case that's an issue.
Okay. What about the state must proffer a proposed victim impact statement in writing?
We normally do that, Your Honor, just I believe it works better that way.
Okay.
The pretrial rulings on the admissibility, so I have no objection to that, I guess.
Okay, the testimony must be limited to the prepared statement, right?
Yes.
Okay.
Yes.
And you agree no witness, either for the state or the defense in penalty phase can testify if they cannot control their emotions,
I
right?
do agree, Your Honor.
Okay. So as to Rashad Murphy's motion to limit victim impact evidence, it is denied as to paragraph A, and that only one witness may testify. However, if we get to penalty phase, Mr. Hernandez, if you want to renew an objection, if the state you think is intending to call too many witnesses for victim impact, then you can renew your objection at that point in time, once we get down to the actual evidence that's coming in. But generally speaking, paragraph A is denied. At this point, I'm going to grant paragraph B that the witness must be an adult. Again, if for some reason we actually get to penalty phase and the state intends to call a minor, we just need to talk about it before you do it, Mr. Harmon.
Yes, Your Honor.
C, the state must proffer a proposed victim impact statement in writing. That's granted, and that victim impact statement needs to be provided at least 24 hours before the witness testifies. So that way, if there's a problem, we can discuss it. All right. I will agree to hold a hearing on the admissibility of the evidence if there's a dispute. Okay, so that's granted. Paragraph D. E, the court must consider relevant case law. I concur, I must, so that's granted. And the testimony must be limited to the prepared statement. That's granted, that's paragraph F. And paragraph G, no witness may testify if the witness is unable to control his or her emotions, so that's granted. Okay.
Your Honor, the next one, number 11, is a motion to preclude application of the most recent amendments to Florida Statute 921.141. In this case, as such application would violate Florida Statute 775.022, where our position is, Your Honor, that for the death penalty to be imposed, there should be a unanimous 12-0 and as opposed to an 8-4.
Okay, state you filed a response relying upon that.
Yes, Your Honor.
All right, I will deny the motion.
Your Honor, number 12 is motion to preclude imposition of capital punishment on the ground that the death penalty is presently administered as per se cruel and unusual punishment. And I would rely on the memorandum of law that is attached.
Okay, and state, let's see, you filed a response. Are you relying upon that?
Yes, Your Honor.
Okay, I'll deny the motion.
The next one, Your Honor, number 13, is a motion to preclude the imposition of the death penalty. And again, I would rely on the memorandum of law that is attached.
All right, state you filed a response. Are you relying upon that?
Yes, Your Honor.
Okay, deny the motion.
And then finally, Your Honor, a request for a jury instruction. It is our position that in order for an aggravating factor to be considered by a jury, it should be beyond all doubt, not just reasonable doubt, and we're asking for that jury instruction, and I would rely on the case law submitted.
Okay, state, you filed a response, relying upon that?
Yes.
Okay, I will deny the motion. That's all I have for you, Mr. Hernandez, for Rashad Murphy. Is that all you have?
Yes, Your Honor. Thank you. That's all I have.